The Manhattan criminal trial of Donald Trump is entering a critical phase today. Yesterday, the court heard closing arguments from both the defense and the prosecution in the hush money case, so that's out of the way now. A couple of things happened this morning. The judge will give instructions to the jury about the factors they should consider as they gather to reach their verdict. After that, there is nothing left but for the jury to deliberate. How long could that go on? That's one of the things that we're speculating about, but only the jurors know. Defense attorneys for Donald Trump went on for about 2.5 hours yesterday with their closing arguments. Then the prosecution stepped in with about 5 hours of arguments as they made their final case to the jury. Jeremy Saland is with us for more analysis on this, a criminal defense attorney, a former assistant district attorney in the Manhattan DA's office. Thanks again for coming in.
Pleasure.
As you have watched all of this, we get to the moment of closing arguments. How important is that? When I watch a courtroom drama on TV, it all comes down to the closing arguments as though nothing happened during the trial itself. Have jurors typically made up their mind before that?
I wish I could have that answer, but juries depend. I mean, every juror is different. But the closing arguments is just that. It's the argument where you can sort of marshal all of your evidence together and hit those main points that you want to hit, make sure the jury understands, and really connect with the jury. Because before that, not that it's necessarily dry, you're not really getting up into their proverbial faces and sharing your story.
A lot of time with the Trump defense team was essentially spent chipping away at the credibility of Michael Cohen. Right. Does that mean that they didn't have much to chip away at in terms of the facts?
Well, they worked with what they had. That's somewhat fair. But their goal and objective is to make this not about falsifying business records, but to convince this jury it's about a guy with a vendetta who's an angry, small-minded person, a.k.a. Michael Cohen, who's out to get the former president. Also, you have this blackmailer, sextorter in Stormy Daniels, and sway it away from what the four corners of the indictment are.
So I think one of the things in the prosecution's closing argument that really resonated, as I heard point by point, was when they said, hey, if this was really about Donald Trump being embarrassed and wanting to keep this news away from his family, that would have happened in 2006. They're making the argument that because Trump waited 10 years, allegedly, that it has to be about the election because it was all that time later before this became so important that there was a hush money payment.
Well, absolutely, because they're not necessarily mutually exclusive. You can actually care about your family and protecting your family and also have the intent to sort of fix and protect the election too. I really think, to your point, the defense was really on and really about Michael Cohen, whereas the prosecution did a much better job of laying out that narrative and explaining step by step, talking about the quote-unquote smoking gun with the Weisselberg handwritten notes, and explaining all that foundational evidence that supported Michael Cohen. It wasn't just on his shoulders.
We're not really at the sentencing phase of this because there's not a guilty verdict yet. But one of the things that the Trump defense team brought up yesterday was the idea that, okay, if there is a guilty verdict, there shouldn't be jail time associated with this. Is this the appropriate time to be having that discussion?
It was a little bit worse than that. It was basically sort of guilting or scaring the jury into thinking, you can't put this guy in prison for what he's done, even if true. That's wholly inappropriate. It's not the appropriate forum, and that was not a mistake. That was a calculated move to sort of nullify, if you will, the jury's case or the prosecution's case, and to put into their mind, you could be sending the former president to prison, and that's not okay.
What typically is included in an instruction to the jury?
Well, you have to charge on the actual law itself. What's proof beyond a reasonable doubt? To your average person, they're not going to know what that is. What's intent? There's a longer version and a shorter version. What are the elements of each crime? So those are the basic things. There are other things that may come in, for example, if someone's an interested witness as a matter of law. There's a lot of different factors. What's circumstantial evidence? What's acting in concert, meaning being with someone else doing a crime? So those are the type of standard things that you would see in a jury instruction.
And you've got these 12 people, they are gathered together, they're deliberating, they have spent a lot of time with each other, but typically one or two people will emerge as thought leaders. They'll try to win others over to a particular position. What typically would be the back and forth between jurors? Would they break it up on a charge by charge basis? Would they just poll the room and see what the initial read is?
So, sitting as a prosecutor and a criminal defense attorney, I've worn both hats. Obviously, I'm not in the jury room, but we do at times speak to them after the fact. And it's a lot of give and take and a lot of back and forth. There's not necessarily any rhyme nor reason. Every juror and every jury is different than another. So I can't tell you what exactly or how they'll do it. And there's been some sort of thought about the fact that there's 2 attorneys on this jury. Are they going to be given more weight? And they should not be. They should be equal. And I've said this a couple of times, sort of with the Orwellian view. It's not all jurors are equal and some jurors are more equal than others. Every juror is the same and should be treated the same and respecting back and forth each other's opinions. And then the foreman will ask the questions and the foreman will read the verdict.
And these jurors have been coming and going. They have not been sequestered.
They have not. That really doesn't happen anymore, at least not to the extent it used to. Being there until 8 o'clock last night was sort of sequestered enough in and of itself.
That's true.
Hours and hours of summation. But no, they're not going to be held overnight in a hotel room.
You've been generous with your time in terms of all this analysis. I think we're not quite done with this yet.
Close.
Thank you for coming in with your insight this morning.
My pleasure.